On July 31, 2026, 7 justices of the Arizona Supreme Court voted unanimously, and the law changed for every child in the state. Their ruling: when a father confessed to abusing his children inside a church, the church had no legal obligation to tell anyone. The attorney representing the victims called it exactly what it is. Quote, "This gives all religions absolute immunity to keep child abuse secret." To understand how that ruling happened, we have to go to Bisbee, Arizona, a small border town, a local church, and a man named Paul Adams. Paul Adams was a DHS Border Patrol agent working the Naco, Arizona crossing. He was also a member of the local LDS ward, a husband and a father of 6 children. The Church of Jesus Christ of Latter-day Saints is not a fringe institution. It has more than 17 million members worldwide and is one of the wealthiest religious organizations in America. In the LDS system, each local congregation is led by a bishop, a lay leader, not a professional clergyman, who holds doctrinal authority over his ward's members. The Bisbee ward had 2 bishops during the years this case covers. First, Bishop John Herod, who served through approximately 2012. According to court documents, Herod was also the Adams family's personal physician, giving him a dual role that would become a central issue in the litigation. Then, Bishop Robert Kim Mozzie, who took over the Bisbee ward in 2012 and served through 2018, per his own sworn declaration filed in the Cochise County lawsuit. In 2020, 3 of Adams' children, identified in court records as Jane Doe 1, Jane Doe 2, and John Doe, filed a civil lawsuit in Cochise County Superior Court against the church, both bishops, and their spouses. That lawsuit put 6 years of church decisions under legal scrutiny for the first time. And what those documents reveal is the architecture of a system, not the failure of 2 men. Let me explain exactly how that system works, because it is not accidental and it is not unique to Bisbee. LDS doctrine requires members who commit what the church calls serious sins to confess to their bishop. This is not optional. It is a spiritual obligation embedded in church teaching. Once a member confesses, the bishop is bound to keep that confession confidential. He may share it only with, quote, authorized ecclesiastical leaders, a category the church itself defines. On July 31, 2026, the Arizona Supreme Court ruled that courts and juries are constitutionally barred from examining whether a bishop correctly applied that doctrine. Vice Chief Justice Lopez IV wrote, "Any further inquiry into whether Paul's admissions qualify as confessions is explicitly doctrinal." In plain language, the church gets to decide what counts as a confession. A judge cannot second-guess it. A jury cannot review it. That is now Arizona constitutional law. That is layer 1 of the silent structure. Layer 2 is where it gets more operational and more alarming. The LDS Church operates a nationwide abuse helpline, a phone number that bishops can call when a member confesses to abuse. When the call presents a legal risk to the church, it is routed, not to social workers, but to attorneys at the Salt Lake City law firm Curtin McConkie. According to sealed court records reviewed by the Associated Press, all calls referred to those attorneys are protected by attorney-client privilege, and every record of those calls is destroyed at the end of each day. Let that structure land for a moment. A bishop calls the helpline with a confession of child abuse. A church attorney answers. The advice they exchange is privilege. The record vanishes by midnight. The attorney who took the call in this case was a man named Merrill F. Nelson. Nelson is a shareholder at Curtin McConkie. He is also, as of 2013, a Republican member of the Utah State Legislature. According to church records filed as evidence in the Cochise County lawsuit, Nelson held multiple conversations with Bishop Herod and later with Bishop Mozzie over a 2-year span. Those records show Nelson recommended the bishops withhold the information from civil authorities based on church doctrine and the clergy penitent privilege. The result? A privilege inside a privilege. The bishop's pastoral call is confidential. The attorney's advice on that call is also confidential. Law enforcement never enters the equation. That is the machine. Now let's look at exactly what it processed, because the facts of what happened in Bisbee are documented in court records, and they are severe. The receipts. I want to walk through 5 of them in order. Each one is documented in court filings, sworn testimony, or on-the-record reporting. Receipt 1. Around 2010, Paul Adams made an initial disclosure to Bishop John Herod that he had committed acts of abuse against his daughter, then approximately 5 years old. Herod called the LDS Abuse Helpline. According to the Associated Press and KUER reporting on church records, Attorney Merrill Nelson answered and advised Herod not to report to police or child welfare officials. In November 2011, Adams made a second formal confession to Bishop Herod. Herod then asked Adams' wife, Lisa, to join the meeting. Adams repeated the confession in front of her. Lisa Adams refused to report. She would later plead guilty to 2 counts of sexual abuse and be sentenced to 30 months in prison. In 2013, Adams made a third confession, this time during a formal LDS Church Disciplinary Council, presided over by the new bishop, Robert Kim Mousy. The council included non-clergy members. Adams also appealed his excommunication to a church appeals panel, admitting the abuse again, per court records. The church's highest internal punishment was imposed, excommunication. But neither Mousy nor Herod reported a single word to law enforcement. That is 3 documented confessions. 3 times the church knew, and each time the machine produced the same output, silence. If you've ever sat in a congregation where the pastor seemed answerable to no one outside the building, tell me in the comments, did your church ever explain what they do with abuse disclosures? That is receipt 1. The 3 confessions, the helpline call, and 2 bishops following Attorney Nelson's advice, documented in church records entered into evidence in Cochise County Superior Court. Receipt 2. In November 2016, a New Zealand Interpol agent discovered a 9-minute video of Paul Adams abusing his daughter, posted to a dark web network. The FBI, DHS, the U.S. State Department, and Interpol were all brought in. The investigation that should have started in 2010 began in 2016. On February 8, 2017, DHS and FBI agents arrested Paul Adams at his job, the Naco, Arizona border crossing, while simultaneously raiding his home. 6 children were rescued from the Adams home that morning. Adams was charged with 11 counts relating to the abuse of minors. He confessed to law enforcement. He never stood trial. In December 2017, Paul Adams died by suicide in custody. From the first documented church disclosure to his arrest, approximately 6 years. 6 years the machine ran without interruption. Receipt 2. The arrest record, the 6 rescued children, and the 6-year gap between first disclosure and law enforcement action. Confirmed by PBS, the Associated Press, and court records. Receipt 3. In August 2022, the Associated Press published an investigation that forced the machinery into the light. The AP had obtained nearly 12,000 pages of sealed records from an unrelated LDS child abuse lawsuit in West Virginia. Those records documented how the nationwide helpline operates, which calls go to Curtin McConkie attorneys, how privilege is claimed, and the daily record destruction practice, all confirmed in the documents. The records also showed Attorney Nelson specifically, his documented role in the Adams case. The AP reported that church records showed Nelson recommended the bishops stay silent, and that those recommendations were made across multiple calls over 2 years. The Adams children's attorneys sought to add Nelson and Curtin McConkie as defendants. The case was dismissed before that motion was adjudicated on the merits. Receipt 3. 12,000 pages of sealed records confirming the helpline's attorney staff structure and documenting Nelson's role in the Adams case specifically. Receipt 4. On August 17, 2022, the LDS Church issued an official statement through its newsroom. I want to read you exactly what they said. Quote, "In late 2011, Paul Adams made a limited confession to his bishop about a single past incident of abuse of one child. The bishop then called the helpline, where he was advised about how to fully comply with Arizona's reporting laws. The church's own statement confirms the call was made and characterizes the advice not to report as full legal compliance. That is their defense, and the Arizona Supreme Court accepted it. Let me pull the actual mandatory reporting statute. Arizona Revised Statute 13-3620 requires any person who reasonably believes a minor has been abused to report immediately to law enforcement or child protective services. The statute has an exemption. It carves out clergy who receive information through a confidential communication. The Arizona Supreme Court ruled that the church, not the court, decides what that phrase means. Receipt 4. The church's own August 2022 statement confirming the helpline call and claiming non-reporting was lawful compliance. That statement is now part of the public record. Receipt 5. This is the one that locks the door. July 31st, 2026. The Arizona Supreme Court issues its ruling. The vote, 7-0. Vice Chief Justice John R. Lopez IV wrote the opinion. He held that Arizona's mandatory reporting statute and, quote, bedrock First Amendment principles compel our decision in favor of the church defendants. The Court of Appeals had found that Adams' confession before Lisa and before non-clergy council members may have waived clergy privilege, opening a path for the lawsuit to proceed. The Arizona Supreme Court reversed that finding. Whether the disciplinary council members were authorized ecclesiastical leaders is a doctrinal question, and courts cannot answer doctrinal questions. The ruling is binding precedent. Every religious institution in Arizona, every church, every ward, every diocese, every congregation can now self-define what counts as a protected confession. Attorney Lynn Cadigan, who represented the 3 Adams children through every court level, responded the same day the ruling came down. Quote, "We have made it more dangerous, less safe, and give churches complete immunity to hide and conceal sex offenders." Cadigan announced she will petition the United States Supreme Court for review, which means this case is not over, but as of right now, the ruling stands. 5 receipts. 3 confessions heard by church officials. A centralized helpline routing bishops to a law firm. 12,000 pages of sealed records exposing the system. A church statement calling silence compliance, and a unanimous high court ruling cementing it all into state constitutional law. But there is something we have not yet reached, something that makes the July 31st ruling look less like an isolated legal decision and more like the final piece of a coordinated structure. 3 Catholic dioceses filed briefs in this case backing the LDS Church. All 3 have faced their own documented allegations of clergy abuse cover-ups. And in the Arizona State Legislature, reform bills that could have changed this outcome were introduced and blocked. The story of how that happened is where Part 2 begins. A state legislator who openly consulted with Catholic bishops before killing mandatory reporting reform 3 times sits at the center of that story. And there is a number from an Associated Press investigation across 33 states that reframes this entire case as a national story, not a local one. That number is 33. 33 states with a clergy penitent exemption to mandatory reporting law, and more than 130 reform bills introduced over 2 decades that failed to close it. What that number means, and who benefits from it, is the architecture of Part 2. 3 children filed a lawsuit in 2020 expecting the courts to be the last line of accountability. On July 31, 2026, the highest court in Arizona told them that line does not exist, not for confessions heard inside a church. The bishops who heard the confessions cannot be compelled to testify. The law firm that advised them cannot be added as a defendant. The records of those calls no longer exist. And the ruling that protects all of this is now the law. Part 2 follows the warnings that were ignored, the legislators who shut the door on reform, and the pattern of institutions that filed briefs to make sure this ruling landed exactly where it did. Subscribe so you don't miss it.